Hi everyone, I am Dr. Vijayalakshmi, Assistant Professor from the Department of Criminal Law from School of Excellence in Law, the Tamil Nadu Dr. Ambedkar Law University, Chennai. Today, I am going to discuss with you all regarding the crime of genocide. Why we should study about the crime of genocide? What is the necessity to understand the crime of genocide? Internationally, most of the country is facing this problem of causing death either in group or in mass. Either it may be between an unorganized group and the state or between two unorganized group of a country. In recent time, we are coming across this term regarding the genocidal events either in Syria or in Israel or Palestine or in Afghan or in Sri Lanka. So now it is a time to understand what is crime of genocide and what are all the legal applications of this international crime of genocide. Let us get into the discussion. Before getting into the development of crime of genocide, so what is our general understanding about the term genocide? When you heard the term genocide, what we will understand? Whether genocide and homicide are two different perspective terms. How far these two terms are different? Why genocide is not covered in our national criminal justice system? What is the importance of this genocide with respect to this international criminal justice system? As we all know, homicide is killing of an individual or causing death of an individual. It is covered under the Indian Penal Code in the name of the offense as murder. Then what is genocide? Whether genocide is an act of destruction of a group or whether genocide is an act of destruction of a group during the peace of time or during the period of conflict, whether it is an act of violation of human rights or humanitarian law, or whether it is an act prohibited by the United Nations organization. So whether the term genocide has been defined anywhere, whether the term genocide or the act of genocide has been prohibited through any legal statute, what are all the contributions of various scholars in developing this genocide into the criminal act? What are the contributions of United Nations organization in acknowledging and recognizing act of genocide as a crime or an offense are going to be discussed. Let us discuss about the meaning of the term genocide. Because when compared to other crime, genocide is considered to be very barbaric in nature, which is gravest of all inhuman acts which is committed against a fellow human being. This act or this offense is silent till 1944. The international community doesn't know the term genocide. For the first time in the year 1944, the term was introduced to the international community by a Polish author, Professor Dr. Raphael Lemkin, who was a Jew by birth, who was a victim of this Nazi regime, who lost his family member, who somehow escaped from Germany and came to America, and as a victim, he contributed to this international community towards a crime by name called genocide. This term was first coined by Professor Raphael Lumpkin in his celebrated article, which is named as Axis Rule in Occupied Europe, Laws of Occupation, Analysis of Government Proposals for Redressal. So in this paper only, for the first time, he introduced the term towards the international community. This term is a combination of two words. One is genos, another one is side. So genos is a Greek term and side is a Latin term. Geno means either race or tribe and side means killing. So killing of a race or a tribe is to be considered as genocide. So from there it has been developed. How it has been developed is a remarkable contribution by Professor Raphael Lemkin. He started to talk about these inhuman activities right from 1933 onwards in the Madrid proposal, but not by the term genocide. So he came up with several terms and he came up with several deliberation which speaks about causing death with some special intention. So it is not simply causing death of a person by way of either killing or murder. This genocide is something different from that of this murder or killing because it constitutes some hatredness towards the concerned victim or the person against whom it has been committed. So from 1944 onwards, Professor Raphael Lemkin struggled a lot to bring out this crime or this act as a prohibited act, not only nationally, as an international crime. Because when there is no law, when there is no specific legal statute, either to prevent or to prohibit some act, you cannot take action against such an act. So for this purpose, he stressed each and every time, either towards the London Agreement, then later in 1945 UN came into existence. He placed his proposal before the United Nations General Assembly, asking them to take steps to going for an international treaty towards this crime as an international crime to be prohibited and to be prevented. Not only genocide generally, he discussed about various types of genocide such as political genocide, social genocide, cultural genocide, economical genocide, biological genocide, physical genocide, religious, moral, etc. And he gave his varied definitions and deliberation towards each and every type of genocide over it. For each and everything, he compared the act with that of the act committed by the Jews in Germany, and he came up with this that it should be considered as a crime to be prevented and prohibited towards this. So what is the next stage of development from the definition aspect towards the internationally accepted one is the background of the development of this crime of genocide. Why he stressed this? Why Professor Lemkin stressed that we need an international treaty to go for a prevention and punishment of this crime of genocide. Because from the definition itself, from the meaning itself, it states that it is a subject matter of killing or causing death. So it is somehow the act is a crime. For converting an act into a crime, we need a law. We call it as principle of legality, which is supported by two maxims, nullum crimen sine lege, nullum poena sine lege, which means there will not be any crime unless it has been prescribed by any law. Some law must be there to support that such an act is prohibited under so and so law. For example, murder causing death is prohibited under the Indian Penal Code. Domestic violence against women is prohibited under the Domestic Violence Act. Demanding of dowry and dowry harassment is prohibited under the Dowry Prohibition Act. So in absence of any of this act, you cannot go and either prosecute or punish any person for the commission of so and so act. This is nullum crimen sine lege. And nullum poena sine lege, there should not be any punishment which is not prescribed by any law. Okay, Mr. X commits the offense of dowry harassment against Mrs. X. I now know what is dowry harassment, and dowry harassment is an offense under the Dowry Prohibition Act. Without punishment, what can I do? Simply knowing the definition, simply knowing that it is a prohibited act, but without punishment, there is no use for it. So, we need punishment, and that punishment should be prescribed by law. So, it should not be any moral value or societal norms or any other rules and regulation. It must be come through a statutory act. So, for this punishment, for this purpose, Professor Raphael Lemkin stressed again and again the United Nations General Assembly to go for a treaty, because without that treaty or without such an international accepted recognition, it is not possible to go for either prevention or punishment of this crime of genocide. So in the year 1946, United Nations General Assembly accepted the proposal submitted by Professor Raphael Lemkin and forwarded the proposal to ECOSCO, so Economic and Social Council of the United Nations Organization. And that particular organization worked out on the proposal submitted by Professor Raphael Lemkin, and in the year 1946, the United Nations General Assembly passed a resolution to go for an international convention on genocide, and that convention is about converting this act as an international crime, and the convention going to speak about the prevention and punishment of this crime of genocide. So on this basis, the committee worked out severely again and again to make out an effective convention to be come out with a proper outcome. So for converting the proposal into the treaty, 5 countries played a vital role, which has been placed by their argument before the United Nations General Assembly in support of going for a treaty on the crime of genocide is that it is on 5 countries. It is Cuba, India, and on behalf of India, Dr. Vijayalakshmi Pandit was who was the then chairman of the delegation of India, was appeared. Then Republic of Panama and other countries and 2 other countries stressed United Nations General Assembly to come out for a treaty. So India played a vital role in converting Professor Raphael Lemkin's proposal into a treaty, that is the convention. So after several deliberation, several modification, in the year 1948, December 9, the United Nations General Assembly passed a resolution on the crime of genocide into a convention. The convention is named as Convention on the Prevention and Punishment of Crime of Genocide. So once the act of genocide got the recognition internationally, now it has become a prohibited and punishable act, not only nationally, an international crime. Then, while converting the proposal into this convention, United Nations General Assembly recognized that due to this genocide act, the international community has faced lots and lots of loss of humanity. So before this convention, either it may be the Second World War. So during Second World War, again we have 2 types of tribunals. One is Nuremberg Tribunal and another one is Tokyo Tribunal. And that time there was no United Nations organization, and those tribunals were set up only by the victorious powers. So the crimes which has been charged against the accused person of this World War II were only war crimes, crimes against humanity, and crimes against peace. So there was no a term or there was no crime by name genocide. So only in the year 1948 it got. So from 1945 or even before that, the United Nations General Assembly recognized that this Genocide Act has, it it leads to several laws of humanity. And the most interesting part of this convention is that it imposes an obligation towards each and every state party toward this convention. Suppose India being a signatory towards the convention of this genocide, it imposes obligation that each and every state should prevent and punish this crime of genocide. So it is their obligation to undertake measures to prevent and punish this crime of genocide. And the second interesting part is that genocide need not to be committed only during the time of war, because we discussed that if it is World War II, it is a war, so genocide may be committed. So you cannot escape from the clutches of law as because genocide has not been committed during the time of war. So Professor Raphael Lemkin, in all corners, he was very sure that whoever commits or practice the crime of genocide should be punished, and they should not move or escape from the clutches of law as because it was not committed during the time of war. So the convention is very clear that either committed during the period of peace or time of war. And most another obligation imposes on the state is that if the state fails to prevent the commission of this genocide, the state will become responsible for that offense of genocide. So this is called as state sponsored or state responsibility. This aspect was recently upheld by the International Court of Justice in 2015, where though it was only an advisory opinion case, it accepted that as per the convention, it is the obligation of every state to prevent it, and if any state fails to prevent the commission of the crime of genocide, that state should be responsible for the crime of genocide and to receive the further sanction. So these are all some of the most important salient features of this crime of genocide. Let us get into our discussion about what are all the matters involved in this crime of genocide. There are totally only 19 articles are in the crime of genocide, and definition clause comes within Article 2 and Article 3. Though Article 2 speaks about what is genocide and Article 3 speaks about what are all the punishable acts of this genocide, we can consider that these two can be taken into consideration as a definition clause. And Article 4 speaks about the responsibility, and Article 6 speaks about the universal jurisdiction, and Article 8 speaks about the support of the United Nations in combating the crime of this genocide. So let us discuss one by one. Definition clause. Article 2 of the Genocide Convention speaks about the definition of genocide, exact definition. So now it satisfies both nullam crimen sine lege and nullam poena sine lege, that is principle of legality. Now we got the definition and as well as the punishment for this crime of this genocide. So what is the definition of crime of genocide? We can, for the convenience of understanding, classify the definition into two parts. One is actus reus and another one is mens rea. That is intention part and as well as the execution part. So in this video, we are going to use the term mental element for the mens rea and material element for the actus reus. So first part of the definition of the crime of genocide is considered as mens rea, and second part of the definition is considered as actus reus. So the first part of the definition reads as follows. Genocide means any of the following acts committed. Any of the following acts comes within the second part of the definition. Committed with the intention to destroy in whole or in part a national, ethnical, racial or religious group as such. So this was the definition, first part of the definition, which speaks about the intention. So intention is to destroy, either in whole or in part. So destruction of whom? The person may be belongs to a national group, or it may be a ethnical group, or it may be a racial group, or it may be a religious group. So these four groups, and as such, where any of destruction of these four groups with the intention to destroy in whole or in part. So this is the first part of the definition, which speaks about the intention. The second part is that what are all the following acts, because it starts like that, following acts. The act is by killing members of the group. So here Raphael Lemkin gives 5 types of committing this genocide. So as we discussed at the initial part of this video, when we discuss this, what is this genocide? We states that killing, causing death. Whether causing death alone amounts to genocide? No. From the definition, we could see the other 4 types of committing this genocide apart from killing. The second part is causing serious bodily or mental harm to the members of the group. You need not to kill them, but by way of causing serious bodily or mental harm, psychological harm, traumatic pain, sufferings, all this also equivalent to crime of genocide. And the third way of committing genocide is deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part. Not by way of killing, directly causing death, and not by way of causing any injury, bodily or mental harm, but gradually reducing the life condition and make them to die on their own. Not by way of causing death by killing or by causing injury, reducing the life condition and make them to die on their own. And the fourth type of committing genocide is imposing measures intended to prevent birth within the group. So for this definition, in the next video, we could discuss elaborately how come the statutory bodies interpreted each and every type of committing this genocide. So imposing measures intended to prevent births within the group is that, for example, there are 2 groups, A group and B group. A group is committing the genocide against B group. So what this A group is doing, that either segregating all the male members from the B group and committing rape on women of this B group, or what this A group is doing, committing rape or committing sexual harassment against this B group members, particularly women, girls, and by way of killing the male members of this B group. So it may leads to other repercussion of preventing childbirths within the same group, because any child born out of this rape considered to be the child belongs to A group only, because in most of the countries we are following only patriarchal lineage, not the matriarchal lineage. So in such a way, you can destroy a particular group not simply by way of killing or not by way of causing bodily or mental harm, even by way of preventing births within the group. So what are the repercussions of committing rape on the woman of the targeted group is that either that woman or girl are not in a position to go back to their normalcy of life, they may not get into their normal family life, or they may not be accepted by the family or by the particular group. So there won't be any development of the particular group, and by this way you can prevent and you can destroy a group, a particular group. And the fifth type of committing genocide is forcibly transferring children of a group to another group. So either during this conflict, this may happen particularly during this conflict or the period of war. So the targeted group members, so whenever there is a war or any conflict, the first targeted group are only women and children. They are the most disadvantaged and vulnerable group. The children are being transferred from this particular group and transferred to the another group and made them to follow the culture, the lineage of the another group, which will destroy the culture or the lineage of this particular group. For example, if a child transferred from A group to B group. So once the child transferred from A group to B group, the child is compelled to follow the practices, norms, customs, belief, everything of this B group, which lead the child to gradually forget their originality. So by this way, the person can commit the crime of genocide. So these are all the 5 types of genocide where it has been defined in the convention. And Raphael Lemkin again subclassified this 5 types of act into 3 types of genocide. A and B, which is killing members of the group or causing serious bodily or mental harm to the members of the group. This may be called as physical genocide. And C, deliberately inflicting on the group conditions of life calculated. This is called as biological genocide. A, B, C are considered to be physical genocide. D is biological genocide, preventing childbirth within the same group. And E is considered to be the cultural genocide. So by way of transferring the child from one culture to another culture. So he turned like this and subclassified the commission of the genocide by way of these 5 acts. Punishable acts. Okay, so Article 2 defines what is genocide, what is its mens rea and what is its actus reus. Now, Article 3 speaks about what are all the punishable acts which is satisfying Article 2. So, the convention speaks about 5 punishable acts. One is actual commission of genocide, either by way of killing or causing serious bodily or mental harm or deliberately inflicting into the life condition or preventing childbirth or transferring the child. This is actual commission of the crime. The second one is conspiracy to commit genocide. And third is direct and public incitement to commit genocide. Spreading hatredness. The person is not either killing a member of a group or the concerned person is not getting into the conspiracy of committing this genocide, but he is spreading hatredness. For example, A group spreads hatredness towards B group. So hatredness, it may be in any form. So it may be orally or through any signs and gestures or through any other depictory manner. So through this way, either by nowadays it is being very common in the social media for spreading hatredness among others or some particular religion or particular group or something else. So this is called as direct and public incitement to commit genocide. And fourth one is attempt to commit genocide. And fifth one is complicity in genocide, which means suppose the genocide has been committed during the period of war. Not all the killing or not all the genocide are being committed by the higher officials like an army commander or a chief or the ministers. Sometimes they may give order. And the person simply obeying the orders of their superior, they cannot come and claim it as an immunity by stating that it is not our own intentional act, but we are only simply discharging the orders given by our superior. So to avoid this immunity, this has been included as one of the punishable act, complicity in genocide by obeying the orders given by the superiors, that also a punishable act under the Convention on Genocide. And next one is about the responsibility, jurisdiction and prevention. That is Article 4 and Article 6. So Article 4 speaks about the responsibility, which is liability. And Article 6 speaks about the universal jurisdiction. So what is this responsibility? Here the responsibility is individual criminal responsibility, because there are cases that we are going to discuss in the next video. Most of the accused persons are higher officials like Prime Minister, like a mayor, like ministers, sometimes the army chief. So those are the persons comes as an accused for the commission of the crime of genocide. So that time they cannot take the immunity, as because they are holding some responsible position, so they cannot be charged for this crime of genocide. To avoid this, Article 4 of the Convention imposes such a strict individual criminal responsibility. Whoever commits the crime, that person should be responsible. They can't delegate their responsibility to others. So if the president gives any orders to commit the crime, that person should come and stand as an accused before the court. And if any mayor who himself either gives an order, who himself commit the crime of genocide, he has to come and face the charges. So it states clearly that whoever commits the punishable act enumerated under Article 3 shall be punished, whether they are constitutionally responsible rulers or public officials or private individual. So individually they should get the responsibility. And Article 6 speaks about the universal jurisdiction. So universal jurisdiction is that where this person should be prosecuted, because it is an international crime. Whether all the states or all the nation has come up with an act to prevent or to punish the crime of genocide, mean no, not all the countries have this act, special act on this crime of genocide. Because the absence of any national legal system, that person should not escape from the clutches of law. He should be prosecuted before any competent tribunal of the particular state in the territory, or by any international penal tribunal which has been with respect to those contracting parties which shall have accepted its jurisdiction. So you cannot move out of the criminal liability as because there is no law in your country or there is no legal statute in the country. So if it is not there, he shall be tried by any competent tribunal or by any such international penal tribunal where that country entered into an agreement with it. So by doing so, no one can escape from the liability or responsibility of this criminal liability for commission of this crime of genocide. So with this, we have discussed so far regarding from where it started, which means who gave the term to the international community. The crime has been introduced by a victim of the crime itself, by Professor Raphael Lemkin, and what are his contributions. Later, how gradually it has been developed into the international crime. What are all the role of this United Nations General Assembly and Economic and Social Cultural Organization. What are all the contributions given by some countries to convert the proposal of Raphael Lemkin into the treaty and the outcome of treaty, and what are all the salient features of the Convention on Prevention and Punishment of Crime of Genocide in the year 1948. So with this, some of the references which will be useful for the audience of this video. So the article from where we got the term and the convention, and some facts about the Rwandan genocide, because in the next video we are going to discuss more elaborately on the Rwandan genocide. and the resolutions passed by the United Nations General Assembly. One resolution is accepted to go for a treaty and another resolution is adoption of this convention, and some other scholarly articles of Professor Raphael Lemkin relating to this crime of genocide. I hope that to some level now today we discuss about the introduction about the crime of genocide. In the forthcoming video, we will discuss about the jurisprudential development of the crime of genocide and the contributions of international penal tribunals. Thank you.